stop scrolling. Did you know that 70% of family wealth evaporates by the end of the second generation, and a staggering 90% is completely gone by the end of the third? It is a terrifying statistic. You sacrifice, you save, you invest, and you spend your entire life building a legacy to provide a better future for your children. But without the proper legal structure, you might be handing them a financial wrecking ball instead of a blessing. Today we are going to talk about how to protect your kids from themselves, their creditors, and their future ex-spouses. We are going to explore the ultimate wealth preservation tool, the Spendthrift Shield. I am the Wealth Guardian, and the mission of this channel is to protect your wealth through education. We bridge the gap between complex legal jargon and practical, real-world asset protection. If you want to keep what you have built and ensure it lasts for generations, hit that subscribe button, like this video, and ring the bell notification right now. And I highly encourage you to watch this video all the way to the very end, because the final strategy I'm going to share with you, a highly specific way to tie your children's inheritance to their own work ethic, is the secret the ultra-wealthy use to ensure their kids never lose their ambition. Before we dive in, please remember that everything in this video is strictly for educational purposes and does not constitute personalized legal or financial advice. Always consult a qualified professional for your specific circumstances. Let us get into it. To understand why so many heirs blow through their inheritance, we first have to understand the psychology of sudden wealth. Behavioral economists have studied what is sometimes called mental accounting, and there is a related concept I like to call the monopoly money effect. Logically, we know a dollar is a dollar, but emotionally, human beings treat money very differently depending on how they acquired it. We place intense value and respect on the money we earn through our own blood, sweat, and tears. But unearned money, like an inheritance or a lottery win, often feels like play money. When someone views this money as somehow less significant than the money they worked hard to earn, they become highly susceptible to losing it. Because it feels less real, sudden wealth recipients are inclined to take bigger risks, give it away more freely, and spend it faster and more lavishly. Researchers have documented this pattern repeatedly. People who come into sudden money, whether through inheritance, a legal settlement, or a lottery jackpot, are statistically far more likely to end up in financial distress within just a few years if they have no plan and no structure around that money. This psychological trap is exactly why leaving your assets to your children through a standard will is so incredibly dangerous. If you rely on a basic will, the probate court will eventually distribute your assets directly to your heirs, often in one large lump sum. And by the way, that probate process itself is public, time-consuming, and expensive. Your family's financial details become a matter of public record, and court fees and attorney costs can eat into the estate before your children even see a penny. Now, if your kids are minors when you pass away, a judge will decide who manages their money until they reach the age of majority, which is 18 in most states, though a few states set it at 19 or 21 for certain purposes. But once that threshold is crossed, the court-appointed guardianship or conservatorship automatically terminates, and your children receive full and immediate access to their entire inheritance. Ask yourself honestly, what would you have done with hundreds of thousands or even millions of dollars in cash at age 18? For most young adults, receiving an entire inheritance that quickly is a recipe for financial disaster. And here's the thing. Even if your children are in their 30s or 40s, a sudden lump sum can still destroy their financial discipline. Lifestyle inflation kicks in. They buy the bigger house, the nicer car, they start spending at a level that is completely unsustainable, and before they know it, the money is gone. This brings us to the first layer of our defense, the Spendthrift Trust. The word spendthrift literally means one who spends money recklessly or wastefully. A spendthrift trust is specifically designed to protect assets both from outside creditors and from the beneficiaries themselves. Here is how the Spendthrift Shield actually works. When you create this trust, you transfer your assets into it, and you designate a trustee, someone you trust deeply, whether that is a family member, a close friend, or a professional corporate trustee, to manage those assets according to your written instructions. When you pass away, the income generated from those assets, such as interest, dividends, or rental income, can be made available to your children according to the terms you set. But crucially, the beneficiaries cannot freely access the principal whenever they want. Because your children do not have direct ownership or unrestricted control over the trust principal, their creditors cannot reach it either. Under the laws of virtually every state, a properly drafted spendthrift clause prevents creditors from attaching or garnishing trust assets before those assets are actually distributed to the beneficiary. Now, I do want to flag one important caveat. There are certain types of creditors that can sometimes pierce a spendthrift trust, depending on your state's laws. These typically include the IRS for federal tax liens, state tax authorities, child support and alimony obligations, and in some jurisdictions, claims for basic necessities. So while a spendthrift trust provides powerful protection, it is not an absolute shield against every possible claim. This is exactly why you need to work with an experienced estate planning attorney in your state who understands the specific rules that apply to you. But for general creditors, civil lawsuit plaintiffs, and most other third parties, the core wealth you built is secure from both the beneficiary's poor decisions and their creditors' attempts to collect. But the protection goes even further, and this is where it gets really compelling. One of the greatest threats to your family's wealth is a child's future divorce. Divorce rates remain significant, and the financial consequences can be devastating. If you simply leave your assets directly to your children in a lump sum, and they eventually go through a divorce, there is a real risk that part or all of those inherited assets could be claimed as marital property and divided in a divorce settlement. This risk increases dramatically if your child commingles the inherited funds with marital assets, for example, by depositing the inheritance into a joint bank account or using it to buy a home titled in both spouses' names. However, with a properly structured spendthrift trust, the principal remains inside the trust. Your child is a beneficiary, not the owner. Because they do not own the assets outright, those assets are generally not considered marital property and are far more difficult for a divorcing spouse to reach. The wealth stays within the family bloodline. It passes down to your grandchildren, remaining protected regardless of your child's marital difficulties or any civil lawsuit they might face. Family's legacy. Let me pause right here. Have you ever watched a friend, a family member, or someone in the public eye completely blow through an inheritance because they received too much too soon? Or are you actively worrying right now about how your own children will handle the wealth you will inevitably leave behind? Drop a comment below right now and tell me your thoughts. I read every single comment, and let us get a real conversation going in the comments section so we can all learn from one another's experiences. Now let us move to the second layer of the shield. What if your concern is not just about lawsuits or divorce, but about your child's ambition? This is a fear that keeps many successful parents up at night. They are terrified that if they leave a massive trust fund to their kids, their children will simply quit their jobs, lose all motivation, and never develop the resilience and work ethic that created the wealth in the first place. There is actually a term for this in wealth management circles: affluenza. The idea that too much unearned wealth can erode a person's drive and sense of purpose. And if you have a child who is particularly vulnerable, perhaps someone who struggles to hold down a job, who has issues with substance abuse, or who simply has not yet found their direction in life, you need the flexibility and control that a carefully drafted trust can provide. We call these specialized structures incentive trusts or motivational trusts. With a motivational trust, you retain meaningful control, even after you're gone, over how and when your heirs receive distributions from the trust. You do not have to leave your 21-year-old $500,000 in cash all at once. Instead, you can stagger the distributions across key milestones. For example, you can instruct the trustee to distribute 1/3 of the trust assets when the beneficiary reaches age 25, another third at age 30, and the remaining balance at age 35. This approach gives your children time to mature, to develop financial skills, and to demonstrate that they can handle increasing amounts of responsibility. If they make mistakes with the first distribution, they still have 2 more chances to get it right, and hopefully they have learned valuable lessons along the way. If you want to take it a step further and actively encourage a strong work ethic, you can add specific beneficiary requirements, essentially conditions that must be met before any distribution is made. For example, you could structure the trust to pay out a percentage based strictly on your child's earned income. The trust document could specify that distributions are tied to what your child earns through their own employment or self-employment. If your child decides to quit their job and not work for a year, the trust provides them with nothing beyond what is necessary for genuine emergencies, if you choose to include that safety valve. But if they get their act together and earn $40,000 at their job, the trust could be directed to match a portion of that income. Say you set it at 50%. Now your child receives an additional $20,000 from the trust on top of what they earn. This way your child has a powerful financial incentive to develop a career, build skills, and become self-sufficient rather than simply living off the trust fund. The more they earn, the more they receive. It is a built-in reward system for productivity and ambition. You can be as creative as you want with these conditions. You could write the trust so that nothing is paid out until the beneficiary graduates from an accredited college or university. You could include provisions that reward starting a legitimate business, completing vocational training, or even contributing a certain number of volunteer hours to charitable causes each year. Some families include provisions for distributions to cover specific approved expenses like a down payment on a first home or the cost of starting a business, subject to the trustee's review and approval. The key is that you are not just giving money away. You are using your wealth as a tool to shape positive behavior and reinforce the values that matter most to your family. Now, one word of caution on motivational trusts. You want to make sure the conditions you set are reasonable and not so rigid that they create unintended problems. For instance, if you require earned employment income, but your child becomes a stay-at-home parent or develops a disability that prevents them from working, an overly strict trust could leave them without any support. This is why it is essential to include some discretionary language that gives the trustee flexibility to adapt to changing circumstances. A good estate planning attorney will help you strike the right balance between structure and flexibility. The final layer of the spendthrift shield does not happen in a lawyer's office. It happens at your kitchen table. Giving money to your heirs is one thing, but it is another thing entirely to ensure that they know how to manage and grow it. Studies consistently show that financial literacy significantly reduces the odds that inherited fortunes dissipate within a single generation. You must start engaging your children or grandchildren early by discussing basic money management, investing concepts, budgeting, and the difference between assets and liabilities. True generational wealth is built when families transition from thinking in terms of working for money to making their money work for them. Do not keep your wealth a total secret until the reading of your will. That approach almost guarantees shock, overwhelm, and poor decisions. Instead, have open, age-appropriate conversations. Start simple when they are young. Talk about saving a portion of every dollar they receive. As they get older, introduce them to compound interest, diversification, and the basics of how different investment vehicles work. You can even create real-world learning experiences, like running a small family investment committee where younger family members research potential investments and present their findings to the group. Give them a small allocation of real money to manage and let them experience both the satisfaction of gains and the sting of losses while the stakes are still low. Encourage formal education in personal finance, whether that is through school courses, books, online resources, or mentorship from trusted advisors, and tie their financial decision-making to constructive family goals and values so they understand that wealth is not just about accumulation, but about stewardship, responsibility, and making a positive impact. Ultimately, an educated heir can handle an inheritance responsibly, continuing the family's legacy and ensuring that the assets remain a lasting benefit rather than a fleeting windfall. Leaving wealth to your children without structure, without protection, and without education is not a gift, it is a burden. By utilizing spendthrift trusts to lock away the principal from creditors and ex-spouses, by creating motivational trusts with staggered distributions and income-matching provisions to preserve their ambition, and by investing the time and effort to teach them financial literacy from an early age, you give your life's work the best possible chance of surviving to benefit your grandchildren and great-grandchildren. You transform your wealth from a potential source of destruction into a genuine multi-generational blessing. I want to hear your thoughts on this. Head down to the comments right now and let me know which of these strategies resonates with you the most. Are you going to set up an age-based staggered payout? Do you love the idea of matching your child's earned income to keep them motivated? Or is financial literacy at the kitchen table the area where you feel you need to start? Let me know below. If you found this video valuable and you are committed to protecting your family's financial legacy, please hit that like button, subscribe to the channel, and ring the bell notification so you never miss our weekly wealth protection blueprints. Remember, building wealth is hard, but keeping it in the family is even harder. Stay prepared, stay protected, and I will see you in the next video.